Go ahead and get started right at noon because we want to leave plenty of time for questions. So my name is Courtney Noll, and I am the managing attorney of the Legal Aid Office of Western Missouri in Warrensburg. And today, as part of our grant from HUD, we're going to be sharing with you some tips for a successful tenancy and avoiding eviction. And when deciding what we wanted to talk about in this next set of trainings, something that I'm really passionate about is the idea that really the best defense to an eviction is a good offense. Unfortunately, in Missouri, because our CaseNet system is online, a lot of landlords will just log on, check out a prospective tenant, and when they see an eviction pending or a recent eviction in the past, they just don't even consider that tenant anymore without looking into the details. So today I really want to share some tips on how we can avoid an eviction getting filed. Just so everyone's aware, the presentation is being recorded and the link will be available soon for everyone. It'll be emailed out. If you have any questions, you can put them in the Q&A box. We've got a couple other folks online that will be helping answer questions, but we may not be able to get to all of the questions. We'll try to get to as many as we can. We can't offer any individualized legal advice as part of this presentation, but we'll try and answer all of the general questions that we can. I'll be speaking for about 30 minutes, and then we'll have about 30 minutes at the end for questions. So if you've got any, throw them at us. So really, a successful tenancy starts even before you rent the property. I advise folks to start with a clear idea of what they need in a home, how much they can afford to spend, and what areas they want to live in. You can't really have a successful life if you don't have stable housing. It really is a fundamental need that we all have. So putting in the time and the effort to figure out what works best for you and your family is really important before you agree to any property. Try and give yourself as much time as you can to find a place, so you don't have to rush into something that you're not comfortable with, especially with the market as it is right now. We're seeing a lot of folks that are just coming to us saying, well, I didn't really like this place, or I knew there were things wrong with it, but I didn't have a choice. There was nothing in my price range. So, planning ahead isn't always going to be the solution, but if you can give yourself as much time, you'll have many more options. Inspect a property before you sign a lease or make any payments. A lot of landlords include this in their normal procedure, but it's always important to actually physically see the property. Real estate agents and landlords are really good at taking pictures that make a property look really nice. But if you've ever, seen pictures and walked to a house and wondered if you were really in the same place, that's one of the reasons why we encourage people to physically go to the property. Don't just trust pictures. Don't just trust what someone else is telling you. You want to make sure that you can see it. Ask questions if you've got concerns. And additionally, if there are issues with the property before you move in, try your best to have them resolved before you take possession. A lot of times landlords will say, oh, well, the furnace isn't working, but it's August, so you don't really need it. But I don't get it done before it gets cold. And then usually what happens is we get phone calls after the first big freeze because it turns out the landlord didn't keep his promise and didn't get that furnace fixed. So especially for big issues, you want to try and get those resolved before you move in. It's a lot harder to get them resolved after the fact. And it'll also give you a good idea about what kind of landlord you're working with. If the landlord absolutely refuses to work with you, then you may want to consider if this is really the good place for you. So the next topic we're going to talk about is the lease. One of the big things in a landlord-tenant case. So a lot of people wonder, do you need a written lease? And the answer is technically under Missouri law, you don't. Oral tenancies are enforced similar to tenancies that are created by a lease. But I always encourage people to have that written lease. And that's because a written lease provides tenants with a lot more protections than not having a written lease. If you don't have a written lease, usually the landlord can evict by giving proper notice, where if you have a lease, you've got those protections. The landlord can't just kick you out in the middle of your tenancy. So once you've got your lease, we always recommend that folks keep a copy of it along with any additional rules or any other documentation that you're given that describes your rights and responsibilities when it comes to the property. If a dispute comes up or there are any questions, the first thing that's going to need to be looked at is the lease, because that's the basis of your agreement. That's the contract you have with your landlord. Those additional rules and other things are also going to be binding. So if you have questions about, can you do this? Can your landlord do that? We're going to look at the lease. And if you've got a copy of that, you can answer those questions immediately. Otherwise, you may have to go try and get a copy from your landlord, and that can create some issues in and of itself. The landlord may refuse to give it to you, even though they really shouldn't. I've had situations before where the copy of the lease that the landlord had is not the copy of the lease that the tenant signed, but without that, the tenant's copy, it's hard to raise that defense because the judge only has one piece of paper to look at. Make sure you read your lease and that you understand the important provisions as they relate to you. You don't have to read the whole thing word for word, only us lawyers like to do that. But you're going to want to read through it once at least, and then focus on the provisions. And they're going to be things that you are looking out for. You need to know, what is the term of your lease? When does it start? When does it end? What is your rent? How do you pay your rent? When do late fees kick in? Things like that. You're going to want to look for any provisions that that have rules or things that you need to do. Specifically, you're going to make sure you're familiar with the maintenance section. So if an issue does come up with the property, how do you notify the landlord? Whose responsibility is what, and things like that. You can avoid a lot of problems if you just know what is expected of you. And you can also feel more secure if you know what's expected of the landlords, because landlords will sometimes tell you something that's different than in the lease. And under the law, we're always going to fall back on the lease. So if you know that, your lease says that the landlord's in charge of the heating and cooling system, and you need to call him at this number if there's an issue with it, you'll feel better when an issue does eventually arise. Understanding your lease is even more important if you have a less traditional agreement, such as a rent to own agreement, or maybe you've got a deal with your landlord to do some work for the landlord in exchange for rent. Because those less traditional arrangements don't fit well within the law, the court's almost always going to look to the agreement. And especially for, like, example, rent to own agreements, you're going to want to make sure you really know what your agreement says if you miss a payment, because sometimes those agreements say if you miss a payment, you've lost all the equity you've built up. And if you're 10 years into an agreement and you missed one payment because you had to pay medical bills that month, you don't want to have lost out on the equity that you've been building. So it's important, if your obligations are more than just writing a rent check every month, that you really understand what those are. The other example I gave, if say your agreement is not just to pay cash for rent, but maybe you're going to do some work for the landlord, ideally you're going to have that in writing, so you know what's expected of you, how many hours the landlord expects you to work in exchange for the rent. Because again, those agreements are what we're going to look back on if a dispute arises. So if you don't have that, or you didn't really understand it, you thought it was another way, the judge that is looking at an issue is going to default back to that written agreement. So the next tip is probably an obvious one, but it's really, really important. So we wanted to go over it, and that's to pay your rent on time. Late fees and other costs add up very quickly and can make it really hard for a tenant who wants to stay in a property to get caught up. I actually just yesterday was processing an intake where this is what happened. Is the tenant knows they were behind, but they really didn't think that they're behind as much as the landlord is saying. But when we looked at the ledger, there's a lot of late fees, payments that were reversed. And so, oftentimes people think, oh, I'm just 1 month behind, so I only owe that 1 month's rent. But in reality, a lot of those fees have been tacked on. And the way most leases work is that when you make a payment, it goes to the oldest amount due. So say you missed 2 months worth of rent payment, but you're ready to get caught up now. You make, 2 months worth of rent. but that may not get you all the way caught up, because they're first going to look at your oldest amount due, which is probably going to be that first month's rent that you lost, then any late fees, any other charges for that month. And then we're going to look to that second month. Then those late fees, those charges, if your landlord has referred a case to an attorney, there could be attorney's fees added on. Some landlords do have other charges that we've seen added in. Sometimes those are in the lease, sometimes they're not. And so some of those you can get removed, but a lot of times that requires an eviction having been filed, at which case it may be too late for the tenant to really stay in that property and have a peaceful tenancy. So just as often as you can, pay your rent, and pay your rent when it's due. Keep a copy of your receipt. If your landlord doesn't provide receipts, document your payments yourself. If there's a dispute at any point about payments, and if you owe what the landlord says, the judge is going to want to see those receipts. So you want to have copies of those. Keep them in the folder that you've got your lease and your other documents in. Hopefully you'll never need them. But if you do, you'll be very glad, and so will your attorney, that you've got them. Again, not all landlords provide receipts, but there are ways that you can document your payments yourself. If you're making a physical payment as like a check or something like that, keep a copy of it. We oftentimes, where rent needs to be paid, like by dropping it at Dropbox, I've advised folks to either video themselves dropping the payment off, or take somebody with them that would be able to testify when they drop the payment off. It really kind of depends on what your arrangement is with your landlord, but you want to take responsibility to keep your own your own track of what you've paid, because you can't always trust the landlord to do that. If your lease gives you options on how to pay your rent, pick the one that's easiest for you to track the payments in case there ever is a dispute. A lot of landlords are using online portals, which can be really great because you can see the ledger, you see how the payments applied, you can pull everything in one screen and really keep track of it. Personal checks can be a good idea if your landlord will allow it, because then you can go to your bank and request your bank statements and get the information about when those checks were cashed and by whom. Some of the more secure methods, such as money orders or other secured funds, if you're going to go that route, you may want to ask the folks you're getting that from what happens if you need to check. What if you need to check to see when the check was cashed? I know we've run into issues before where some of those, if it's possible to track down those certified funds, it takes a long time, and you oftentimes don't have that amount of time in an eviction case. So if you've got an easy way to track it where the information is available to you, that's a good idea. Not all landlords will give you an option. Sometimes they just say, this is how you pay, and that's it. And there's not going to be a lot you can do about that. But again, in whatever way you're going to be paying, keep copies of those for yourself. So what do you do if you can't pay your rent? Because we all know it happens, and it's not the end of the world, but it is something that you need to keep on top of and deal with immediately. So the first thing that I recommend that people do is, again, because we've kept a copy of our lease, is to review it and understand what their options, rights, and responsibilities are. Specifically, you're going to want to look at, what are the late fees? When did they start accruing? What are your options for breaking the lease? What are your landlord's options for breaking the lease? And if the lease contains any other provisions about payment or eviction, you're going to want to understand what those are. Then you need to be realistic about your finances and what the best options for you and your family are. Again, although everyone who's experienced having to move unexpectedly knows how stressful it is. And you don't want to either remain in a home that you can't afford or isn't good for your family, or leave when maybe it's something you can make work. So we see a lot of folks that, because they can't find anything else, they maybe keep paying a landlord that isn't taking care of them, or they keep giving money to a landlord who's not tracking that money carefully. And while it's not fun to move, nobody ever likes to do that, sometimes that is a better option. If you can, if you've got a good relationship with your landlord, talk to them about the situation early on and see if they're willing to work with you. A lot of times, what landlords really just want is to get paid. And so when the money's not there, they just assume you're not going to pay. They don't care. But if maybe you've got a unique situation going on, you've got a plan that you can get caught up, go talk to your landlord, ask them if they're willing to work with you, see if you can enter into some kind of written repayment plan, or they'll agree to waive some of the late fees or work with you in another way. If you can get that agreement in writing, that's always best, just so if somebody changes their mind later on, there's no questions about it. But starting with a conversation is a lot of times the way to avoid a situation escalating more quickly than you really are comfortable with. If there's rental assistance available in your area, seek it out as soon as possible. This has obviously been a great resource for a lot of folks over the last few years. And while it's less of it is available, there is still assistance out there, and hopefully will be into the future. So when you first start to realize there's going to be a problem, I recommend seeing what's available, seeing what their requirements are, what does the timeline look like, what are the application requirements, so you can be prepared for that. You may not be able to apply for assistance right then, but you want to be prepared for when you are ready to apply, that it's available. You want to know what's available. That way you can communicate that to your landlord. A lot of landlords, have been great with the rental assistance. Some of them haven't been. So you'll also want to know what are your options if your landlord doesn't want to participate. But it's a really great resource when it's available, but you don't want to wait till the last minute, because Missouri law doesn't require landlords to wait on something like rental assistance. And a lot of landlords, at least in my service area, we worked mostly with SAFER on our rental assistance. And one of the issues we ran into is just landlords didn't want to wait for SAFER to take their time in issuing the funds. So if you can start the process early on, then that timeline can be a lot shorter and your landlord may be more willing to be patient with you. So the next section of my presentation is going to be touching on some of the common issues that we see in tenancies and kind of some ways to deal with it. And I'm going to start off with habitability, which is a huge issue in low-income housing, probably one of the biggest issues that we face. And really, it could be a several hours long presentation on its own. So I'm going to just go over stuff kind of briefly. So under Missouri law, landlords do have an obligation to provide a minimum level of habitability in all properties they rent. We call this the implied warranty of habitability, but basically it just says that if you're going to rent out a property for people to live in, it needs to be fit for people to live in. Those standards are a lot of times based on the local codes. And so, the cities have adopted codes that says this is the minimum that makes a property good for people to live in. If there's any issues with your rental property, notify your landlord immediately. If it's a small issue, you don't want it to become a big issue. If it's a big issue, you want it taken care of as soon as possible. There are some options to deal with this that we'll touch on, but really with any remedy that you're going to have, there's almost always going to be an obligation that you gave the landlord an opportunity to fix the problem. So make sure that you are reaching out. I know that can be really uncomfortable. A lot of people don't want to ruffle the landlord's feathers. They are worried that the landlord's going to get annoyed. But if there are issues, they're probably not going to go away. And it's better to deal with them when they're upfront and early on than let them get worse and worse. You may be able to break your lease, your rent obligations can be reduced, or you may even be able to seek damages against the landlord if there are bad habitability issues. So there are options. Unfortunately, though, it's usually not possible to force landlords to make the repairs to allow the tenant to remain in the home at that time. Some municipalities have developed programs such as the Healthy Homes program in Kansas City that provide some more options for that. Subsidized housing that's subject to the HUD housing quality standards has some options as well. But ultimately, at the end of the day, there's no provision under the law where we can force a landlord to make a repair right now. Sometimes what happens is if the landlord won't repair, then the city or the municipality will come in and condemn the home. In subsidized housing situations, if the landlord refuses to make the repairs, HUD will quit paying their portion, and the tenant will need to find a new place to live. So there is also a provision under Missouri law that allows tenants to make repairs and deduct that from their rent. But that statute's really specific and really hard to meet all of the elements. So we, at least in my office, we usually don't recommend that folks try that route. And relatedly, if you just go ahead and make repairs without a prior agreement with your landlord, you may not be able to get credit for that. So if there is an issue and you and your landlord come to an agreement where you'll fix the problem in exchange for however much off your rent, make sure you get that agreement in writing ahead of time before you expend any money. For some folks, it is worth it to put money into a rental home to make it more livable, but you shouldn't count on being able to get those funds back or get credit for that later on. So I'm going to go through a fewer issues that are a little bit less intense than habitability, but are still really important and come up. The first is unauthorized occupants. So most leases, especially if they're subsidized, are going to contain a provision about how many people can live in a property and how long you can have visitors for. And we see a lot of evictions because someone has moved in a partner or a family member or a friend, and the landlord says, nope, that person's not on the lease, they can't live there, and an eviction gets started. So if you're in a situation where you're going to have somebody come stay with you, I recommend, I probably sound like a broken record, but go read your lease, see what it says about unauthorized occupants and visitors. If it's a short-term situation, you can talk to your landlord, explain what's going on, say you're going to have surgery and you've got a family member who's going to be staying with you for a few weeks. Tell the landlord that ahead of time. Most of the time, in my experience, landlords don't really investigate these issues. They just say, oh, well, your neighbor says that some guy's been staying there, or I drove by your house 3 times this week and there was always this car outside, and they just move forward. Where if you tell your landlord ahead of time, hey, this person's going to be staying with me for this amount of time for this reason, you can avoid a lot of issues. There may be some other options you have for getting that person to stay, which I'll talk a little bit about in a few minutes. But it's something that landlords do evict for. And in the subsidized housing realm, it's a lot more common even than with private landlords. The next thing that I wanted to touch on is disturbing other tenants, because this is when there's an eviction based on this, it's one that's really hard to win, because most judges believe that everyone should be able to peaceably enjoy their homes. So if you've got one tenant who's doing things to disrupt or disturb or cause conflict with other tenants, and the landlord tries to evict that disruptive tenant, those cases can be really hard for the judge to rule in favor. On the flip side of that, if you've got a neighbor who you're not getting along with, you're having a lot of issues with, you'll want to document those issues and talk to your landlord about it, because the landlord, may go ahead with an eviction and may be able to do that based on the information you're providing them. The next topic is another kind of broad one, but I'm only going to touch on it briefly, and that's VAWA, or the Violence Against Women Act. And this is a federal law with some state counterparts that provides protections, not just to women, but to all victims of domestic violence. And it does a bunch of other stuff too, but generally for our topic today, the main point is that landlords can't evict folks just because they're the victim of domestic violence. There's a lot of protections available. So if your landlord is trying to evict because there have been fights in the home, and it's just, other tenants have heard, because the police have been called out, because there was some violent incident, there was damage to the property. If that is based out of domestic violence and you are a victim, there are protections available. And I would recommend, if you're in that situation, to reach out to either your local legal aid or a domestic violence shelter, because those are protections that you have to ask for, and you've got to provide some information to the landlord. I will tell you up front, it's probably not going to be all of the information your landlord is telling you need to provide. But specifically in Missouri, there's provisions to allow a victim to get out of lease early without having to follow the lease terms of breaking a lease by just paying a smaller fee to the landlord. Again, landlords can't evict you because you're a victim. And in the subsidized housing realm, there's even more protections, but it can allow you to separate your household from your abuser's household and possibly remain in the unit, even if it's for a smaller number of people than are currently living there, things like that. So there's some really strong protections, but you do need to invoke them. So if you or a friend or a client is being evicted because of domestic violence that's been perpetrated on them, definitely reach out to legal aid to get some more information on that. The next area is another big one, and that's disabilities. And there's a lot of federal and state law protections that doesn't allow landlords, both private and subsidized, to discriminate against folks because of their disabilities. You've got a few tools at your disposal for this. The first is, I think a lot of people have heard of reasonable accommodations, which basically means that you're requesting that the landlord make an exception to their policies or procedures to allow you to fully appreciate and utilize the home, even though you have a disability. So some examples can be, say someone's got a medical condition where that requires them to have an in-home caretaker. You can request a reasonable accommodation to allow you to have another person living in your home, basically full-time, that's not on the lease. A similar thing, if you have a condition that requires a lot of medical equipment, you can request a 2-bedroom unit when you would normally only qualify for a 1-bedroom unit because you have a need to keep that equipment somewhere. You can also make requests for changes to more policies, such as paying rent. If someone's on Social Security disability and their payment comes in on the 5th, but the rent is due on the 1st, they can request a reasonable accommodation to pay their rent on the 6th because of their disability. It's a reasonable accommodation for a reason. The landlord doesn't have to accept just outright what you ask for, but they do have to engage in a conversation with you and find something that is reasonable. The other side of this is what we call reasonable modifications. And that's where you're requesting that a physical change be made to the property. So a ramp be added, grab bars in the shower. Those are treated a little bit differently because the landlord or the tenant may have to carry some of the cost of that, but that's also a protection that's available. The next issue I wanted to bring up is drugs and other crime, and this is specifically been coming up a lot in my office over the last year or so because Missouri has decriminalized and made legal recreational marijuana. But what some people don't realize is that because it is still illegal on the federal level, it is not allowed on in or on the property of federally subsidized housing. So even though you can go buy it at a dispensary and use it at a private residence, if you live in subsidized housing, you may not be able to. You can usually request a reasonable accommodation, like we just talked about, if it's medical use. But I have been dealing with some cases where folks just come in and they say, I didn't know that. So this is another area where you want to make sure you read your lease and your rules, know what the options are. And then for more serious drugs and more serious crime, Missouri does have an expedited eviction process. So if there is something going on, a landlord can get a tenant out of a property pretty quickly. And it doesn't just have to be the tenant. If you invite someone to your home and they do something wrong, oftentimes you're going to be responsible for that. So you want to make sure you kind of know who's coming over and making sure that they're not doing something illegal. So all of these issues that can come up usually lead to some kind of notice. So the first tip I have for those is don't ignore them. A lot of people, get something from their landlord, and whether it's a notice of a lease violation, a notice that they're coming in to spray for bugs, a notice of any change in your agreement, don't ignore that. You need to read it. You need to make sure you understand what it's saying, because if it is going to make a change to your relationship with your landlord, you want to be aware of that. The lease is usually going to say how much notice is required for some changes, but for something like hey, we're doing bug spraying on this date at this time, you need to be prepared for it. That's something that is important to pay attention to. If you receive a notice, especially for something like a lease violation or termination, and you're given the opportunity for a hearing, I always recommend that folks take it if they disagree with the lease violation. I handled a case where a tenant was in subsidized housing and she let her daughter and her daughter's partner stay with her while they were looking for their own housing. And her lease said you can only have visitors for 2 weeks. She let them stay for 2 weeks, and she knew what her lease said, but on the 15th day, they still didn't have another place to go, so she let them sleep on the porch. Well, her landlord sent her a lease violation and said, we consider that to be part of the home. But luckily, she contacted us. We went over with her what the rules were and encouraged her to go to the hearing with her, the informal hearing with the manager. She did that, explained what the situation was, that the folks were no longer staying with her, that she understood the rules now and it wasn't going to happen again. And the issue didn't escalate further. She was able to remain in the home. She was educated. The landlord, I think, really appreciated knowing that she was taking it seriously. And she was setting herself up to be successful in her tenancy going forward. Also, in subsidized housing, we see a lot that those old lease violations can come up again later. So a lot of times the subsidized housing has an additional requirement outside of just Missouri law that there has to be good cause to evict. So what I see landlords doing is that they'll use the new lease violation for what happened 3 weeks ago. Then they'll bring up 6 other lease violations that happened sometime in the last 5 years. Sometimes they're related to the new lease violation. A lot of times they're not. But they'll bring those up to basically try and build a case for good cause. And while it may be easy for us to address a lease violation that happened recently, you may not have any information about what happened 3 or 4 years ago. The people that could support your position aren't around anymore. So if you deal with the notice when it comes up and you take care of it then, it's less likely to be used against you later on. So that's the end of my slides. I've got up here a couple other resources that if you've got questions or you can go to. The first is the motenanthelp.org, which is a recent website that the legal aid organizations have launched. And we're actually going to have a whole presentation about that later on. And then I also included the link to Missouri Legal Services. So it's a website covering all 4 of our programs in Missouri, and it can be really useful for if you don't know who to call, which legal aid office to call. It's got a service area map, and what I can tell you is that generally in eviction cases, you need to talk to the legal aid organization that covers the county where the property is located, because almost always that's going to be where the case should be filed and where the case is going to be tried. So when you don't know who to reach out to, all 4 legal aid offices in Missouri, we all do eviction work. So you can find out who to call there. That way you're not calling around. So feel free now to put your questions into the Q&A, and we will try and get to as many of them as we can. I tried to leave plenty of time for questions. So, and if we run out of questions, we'll see what else we can cover. So the next question is, are landlords allowed to deny an application based on a history of domestic violence? A past landlord is giving a client we were working with a bad reference because of DV that occurred in his property, and new landlords are denying this client based on that bad reference. So I don't think that I'm not aware of VAWA having any provision based on like what a landlord can and cannot say in a reference. So it would probably make a difference on what is he saying. It would be worth, in that situation, what I would probably do is maybe write a letter to the current landlord saying that, we understand that you've been given a reference based on these facts, but you should know that this was because of domestic violence, and that that you can't discriminate based on that. It may be something where if you are discriminated against, it would be worth filing a HUD complaint, and that's something I'll talk about real quick. Is so say, and this is usually going back to the disability thing, but again, landlords can't discriminate based on disability. They can't deny someone housing because of a disability. They can't evict someone because of a disability. They can't treat someone differently because of a disability. So But say the landlord's doing that. One remedy is to file a fair housing complaint. So you start that through HUD, and then HUD will investigate. And depending on what they find, they'll either try and work out the situation with the landlord and the tenant, or they may initiate an action on behalf of the tenant, or they may just make a finding that discrimination has happened. So it would be worthwhile to, once you take a look at what all VAWA covers, I would say if you feel like your client is being unfairly denied, because the fair housing laws don't just apply to people who have already rented out properties. That law does apply to folks who are renting out, and those protections kick in even before you've signed a lease. And the next question I've got is, how does one become a fair housing tester? And I will say that's not something I know the answer to. That's not something that legal aid works with. So I don't know if John, you guys know, but that's something you'll probably have to investigate with HUD.
I would just say, Courtney, that the last of the series is going to be specifically on fair housing. So that might be something that could be answered in that, but that's not something I would be able to answer either.
Okay. So those are all the questions we have right now. So if you've got a question, feel free to throw it in there. But I thought I would, in our last few minutes, an issue that's actually come up in my casework a lot just in the last week is what happens when a property that you're renting gets sold. Because a lot of folks don't know what happens. So generally, the rule is that if you've got a valid lease and your landlord sells your property, the person that's buying it takes the property subject to your lease. So they have to, you're still bound by your lease, and so is the new landlord. There is a provision in Missouri law that requires, if someone buys a property that's currently being rented out and they want to continue to recover the rent, they're supposed to send a specific notice notifying the tenant that they've bought the property. They're supposed to provide a copy of the deed. There's a specific statute. It is, I happen to know because I'm actually going to try a case on this on Monday, but it's 535-081. So if you are renting a property that's been sold, the first thing to know is that no matter what people tell you, don't just assume you're going to have to leave, especially if you've got that valid lease. If you've got a lease that is good for 3 more months, then the new owner is going to be bound by that. You do have to keep paying your rent, though. You don't get to live for free. So usually what I advise folks in that situation is to decide, do you want to stay with the new landlord or do you not? Most of the time, if you want to leave, you're probably going to be able to work out a good deal with the purchaser. If you want to stay, make that connection with your landlord. I had a case recently where that's what happened. The tenant, found out the property got sold through the grapevine, got super stressed out, contacted us, and we said, hey, just, reach out to this person and tell them you're interested in staying. And after one conversation, they were able to work out all the issues. My client knew where to pay rent, and they had a plan for moving forward. I've got the case I'm trying on Monday. The landlord didn't send the required notice and now is trying to sue my client for quite a bit of past due rent. But because she didn't get that notice, she's not bound by that. Now, again, you don't get to live in a property for free necessarily. There are some other options. It's not like it's a get out of jail free card. There are different ways that the landlord can collect. But I think a lot of people, when their property gets sold that they're renting, they just assume that they're going to have to leave right away. And that's definitely not the case. And another kind of general tip is just to stand up for yourself. Honestly, it would be nice if we could trust landlords to be nice and do the right thing. But unfortunately, that's just not the case. And so a lot of times, I'll get calls from people who will say, well, my landlord said this and I did it and I left the property, but now I'm not so sure. It's hard for us to get somebody back into the property. So you have to, you just don't react too quickly. You can always reach out either to your local legal aid organization, another tenant focused organization in your area, or checking out our LAWMO tenant help website. Okay. So another question from Lynette. She's in the resettlement space, and they're finding that many landlords need to accept alternate documentation from refugees during the application process. Is this considered income discrimination because they're not accepting those? So it could be. Again, that's probably going to be a better question for our last session on fair housing, because some of those questions get a little tricky. You've got to look at both the federal and state law. Missouri, as we all probably know, is not the friendliest state to tenants. But I will say generally, if a landlord is just doing something just to do it and there's no real reason for it, and it feels like it's not right, that's usually a good sign that there might be something going on. So you would want to look into it. But Lynette, I really encourage you to join in our last session on fair housing, where you'll get to talk to someone who knows a lot more about it than I do. So another question is, what are your rights as a tenant if your landlord informs you that the building has been condemned and orders you out of your apartment within the next week? And how does this answer differ if you are currently renting on a month-to-month basis? So really the first question is who has condemned the building? If the city has come in, or your municipality has come in and said no one can live in this building, then it's not really an issue immediately between you and your landlord. If the building is locked, locked up by the city, everything's boarded up, the tenant is going to have to leave. Now there may be the tenant may have a recourse against the landlord after the fact. And it also may make a difference. Whether or not you are on a month-to-month basis probably doesn't make much of a difference. But there are different options for subsidized housing. There are different notices that have to be provided. There are different options for vouchers to move. But at the end of the day, if the municipality has come in and said no one can live in this building, the tenant is going to have to move and then seek recourse from the landlord after the fact. Doreen asks, are landlords allowed to increase rent every 2 years? If so, what are the time restraints on how frequently a landlord can increase rent, how often and how much is the max? So that is mostly going to be determined by the lease. The lease is what we're going to go back and look at. A lot of leases will contain a provision that maybe gives like a 30-day notice or something. And again, subsidized leases are going to be a little bit different. And I don't know off the top of my head what those rules are, but generally in the private landlord tenant space, a lease is just a contract between a landlord and a tenant. So that's why we have to look to the terms of those contracts. So usually you can't, one side can't unilaterally increase the rent without notice to it. Oftentimes the lease will say that the landlord can increase the rent by a certain amount by giving a certain amount of notice. But as far as, in general, under just Missouri law, that's not something that is stated in the law. That's something that's left up between the parties. And like I said, it would be different if you're in the subsidized housing realm, which is not something I talked a lot about today, because those cases get a lot more in depth with, reporting income changes and things like that. But you kind of stop and think about it of, just like the same thing about your Netflix bill. When you sign up for Netflix, you agree to a certain price. But if you've had Netflix very long, you've gotten several of the emails that said, starting at this date, we're going to increase the prices. And so your lease is going to be a similar thing. It's probably going to say, this is how long we have. If a landlord does unilaterally change the rent, that may be grounds, because just like a tenant can breach a lease, a landlord can breach a lease too. So if the landlord does something that goes against the lease, the tenant has the option to bring a suit against them for breaching that. So if a landlord all of a sudden says today, you got to pay me $1,000 a month where the rent was $300 before, starting now, and I'm going to evict you if you don't do that, you're going to have a pretty good defense to that case, unless your lease that you signed says that the landlord can do that. And that kind of ties back into what I was talking about at the beginning, where it's really important to read your lease, because the law will assume if you sign a contract, including a lease, that you read it and understood it. There's some leeway in there, but generally you can't walk into court and say, well, Your Honor, I didn't read my lease, so I didn't know that, in 6 months the landlord had the option to add on this fee and I didn't want to pay it. The judge will have assumed that you read it and generally understood it, especially if it's written in plain language. And again, in a lot of these questions, you'll see the theme, we keep going back to documents like the lease, and that's because that really is going to be the basis of your agreement. And rarely can I, as an attorney, answer a question about a tenancy with a lease without having read it. And almost every intake that we do on evictions, one of the first questions we ask is, do you have your lease, and send us a copy of it, because I'm going to go through it. I'm going to, I need to see what exactly it says about the certain issue, and that way I can advise a tenant. So what happens in a month to month if they sell the building? How long will you be given to vacate? So the same notice requirements is going to require generally for an unlawful detainer, which is the kind of eviction that's filed when there's not necessarily a traditional landlord-tenant agreement. The Missouri law is pretty clear that the proper notice to terminate a month-to-month tenancy is one rental period. So if you pay your rent on the first, say I own a rental property and I'm going to give my tenant a notice today, October 25th, I collect rent on the first. If I provide a tenant with a notice today, the earliest that I can require them to leave is the end of November. So I've got to give them a full rental period of notice. So they'll have the entire month of November before they have to leave. So that's going to be the same if the building is sold. I will tell you that I rarely see month-to-month tenancies properly terminated. In fact, when I do see one, I am kind of shocked, because most people assume that they only have to give 30 days notice. And the statute's not written as clearly as it could be. But Missouri courts have issued several cases that make it clear that it's not 30 days, it's a rental period. Normally rent is due on the first. So unless you have a consistent agreement that you pay your rent on another day, we're usually going to be looking at that first of the month. All right. I think I've covered most everything that I wanted to today. So if anyone else has any other questions, feel free to throw them into the chat, but we really appreciate everybody joining in today. And again, it's evictions work is a real passion of mine. Again, like I said, it's really hard for folks to thrive if they don't have stable housing. And unfortunately, the law really doesn't favor tenants. So, we all of us here at Legal Aid are here to do everything that we can do. But in order for us to really be effective, we need our clients to help. And when we get a phone call of, hey, I've got an eviction case going to court tomorrow, what can I do? That's awfully late in the process for us to really be able to make a difference. There are some things you can do. But the earlier you can deal with these situations, the better. The other situation that we see a lot is that if you have an issue that goes on long enough that you and your landlord just cannot get along, those become really tricky cases for us to help you with, because on the one hand, sometimes there are legal defenses we can keep you in the property. But unfortunately, when landlords decide they don't want someone on their property anymore, it's only a matter of time before they're going to be able to get the tenant evicted, and whether there's a lease or not. So, a lot of times when people try and deal with problems themselves, there's just a lot of frustration. So I definitely encourage, if you have a landlord who is really frustrating to work with, reach out for help as early as you can, because, you know, we may be able to work something out, but if we get to the point where the landlord hates you, you hate the landlord, everyone's just mad at everyone else, it's hard for someone to live peaceably in that situation. And it's harder for us to, you know, make deals and arrangements, and buy people more time to find a new place to live, because at the end of the day, it does, you know, if a landlord wants somebody out of their property, they're probably going to be able to do it. So the earlier you can advocate for yourself or advocate for your clients or other folks, the more likely it is that you are going to have a good result. And so before we end up, we've got, you know, HUD requires that we let you all know that, you know, that the content of the publication is my own, doesn't reflect the views of the federal government or anything like that. So I appreciate everyone joining us today. I will hang out for a few more minutes if there's any questions, but that ends our presentation.